semester, and I'm going to hand things over to Sandeep to get us started.
Thank you. And thank you all for being here, and those of you who are joining us online. I just want to quickly introduce the goal of this series generally is to have conversations about law or non-lawyers, and generally sort of try to cover some more technical areas of law, but today is a bit different from that, particularly in terms of ways of thinking about law, not necessarily the area of law. And obviously, because this is something that a lot of people have asked us for, and it's sort of, kind of a session on law and Marxism. So we're very, very glad to have two people who are actually writing a book on this. So we'll come to that. Let me first introduce them. First, on the far right, over there, well, on the right edge of the table, we have Rafael Khachaturian, who's from the University of Pennsylvania. His research focuses on intersection of contemporary democratic theory, critical theory, and history of social sciences. His manuscript in progress, The Discovery of State, Crisis in Knowledge Production in Post-Political Science, is a study of how the emergence of critical perspectives of social science help revive theorization of the state among political scientists. His work has appeared in The Nation, Jacobin, Dissent, Polity, Contemporary Political Theory, Political Research Quarterly, and more. He is also the co-editor of Marxism and the Capitalist State, which was a new debate published last year by Paul Ring. And perhaps most relevant to us here is alumni of the New School. And so welcome back to the New School. And then right next to me, I have Igor Shoikhedbrod, who on the, as it turns out, I put myself on intentionally. He is, he's from the St. Francis Xavier University. This is in New York there. He's the author of Revisiting Marxist Critique of Liberalism, Rethinking Justice, Legality, and Rights, published in 2019 from Galbraith. His scholarly works have appeared in journals such as Contemporary Political Theory, the Canadian Journal of Law and Jurisprudence, Critical Analysis of Law, Critical Horizons, Hegel Bulletin, The Owl of Nerva, and the Marx and the Review of Books. Igor is currently working on a second book project, which focuses on global financial capitalism and the crisis of the legal form. And one of the reasons they're really here is they're together translating and editing a volume, I think, really necessary volume on Soviet legal theory. It's called The Revolution of Law, Development in Soviet Legal Theory, 1917 to 1931. They published by Brill and then Haymarket Books in very near future, hopefully, yeah? Okay. So thank you both for joining us. So the way we'll do it is I just, my role is quite peripheral here. I just ask kind of, just structured questions, start the conversation, and they'll do the rest. Okay. So if we just start with the question, which is the topic of the panel, which is what is the Marxist view of law? So you can start with that.
Well, perhaps it's best to first of all, we'd like to thank the organizers for inviting us. And it's really a pleasure to be here. And what we're most interested in is a conversation, kind of a back and forth. And we'll start kind of with the abstract, sorry to put the Hegelian lingo in, and then proceed to the concrete by asking, the first question, namely, what is law from a Marxist point of view? And we thought that the best way to begin is by perhaps beginning with kind of the conventional interpretation of law and Marxism, right? And the conventional interpretation is a very instrumentalist one, a reductionist one, that law is kind of epiphenomenal, right? That it is a reflection of the will of the ruling class. And sometimes what we find is that the Communist Manifesto is sort of a go-to document or pamphlet. And in particular, the way that the modern state is portrayed in the Communist Manifesto as being the representative arm of the bourgeoisie and nothing more than that. What's sometimes forgotten is even there, it's not direct ruling class rule, if that makes sense. It's a committee, right, for basically administering the affairs of the bourgeoisie. And I think that's going to be a very important point because some of the thinkers that we're going to be considering today don't fit very neatly in this class instrumentalist reductionist manner, where law is nothing other than the will of the ruling class made into law, right? Binding and coercive law. So I thought it'd be good to start there. because that's the usual kind of interpretation that we get of Marxism on law. What is law? It's basically class politics by any means, and class politics means here law is the instrument of the ruling class. Right, so I'm sure most of you are kind of familiar with this interpretation. Now, what we'd like to do is to complicate things a little bit by trying to emphasize the extent to which law is more than just the will of the ruling class. Right, and I think this would be a good opportunity perhaps to make transition.
Can everyone hear me okay? I'd also like to thank the organizers of LPE for bringing us here. I just want to add that when I was a student at the new school, this building did not exist yet. It was just a 3-story former department store that operated as a new school for social research. So it's kind of fun to be here now. I'd like to pick up basically where Igor left things off, but also add a couple of maybe I guess contextual points. So one thing is that it would be misleading to say that there is the Marxist theory of law, just as it would be misleading to say that there is the Marxist theory of the state. Both law and state are fields or domains about which Marx did not provide a systematic analysis that could be comparable to the critique of political economy. So we don't actually have. Marx did plan in the 1850s to dedicate a separate volume of the larger project to discussion of the state and of law. He never got around to it. So part of the really what makes the Marxist tradition following Marx's death and picking that up from Engels is the attempt to fill in some of these gaps and to reconcile some of these tensions and perhaps contradictory accounts when it comes to things like the law and the state. So the history of Marxist thought about these topics is in a way inseparable from the concrete political debates that were happening among kind of waves of Marxist theoreticians and activists from the late 19th century up through the end of the 20th and into the present. Now, when it comes to this question of law, as Igor said, when we speak of class instrumentalism or a kind of crude, reductive understanding of what law is and what the purpose of law is socially, we have to come back to the metaphor of base and superstructure. This is something that Marx and Engels, mentioned in a number of their works. Perhaps most famously, it's articulated in Marx's 1859 preface to the Contributions to the Critique of Political Economy. And essentially, what we have with this topographical metaphor is an understanding of the base that is composed of the material relations of productions and the means of production, and the forces of production. So the forces of production being land, resources, technology, and the relations of production being the way that the division of labor actually combines and utilizes those in order for society to be able to reproduce itself. And then you have the superstructure. And what goes into the superstructure? Well, it's the state, it's law, it's aesthetics, it's philosophy, it's something that we might call culture, broadly speaking. But anything that is not, let's say, directly and immediately connectable to the reproduction of a society's capacity to survive could be placed within the superstructure. That's the kind of framework that was inherited from a selective reading of Marx, and that was actually quite prominent among what's kind of been known as Orthodox Marxism. So the Marxism of the Second International, which lasted really from the late 19th century up through World War I. Law is a particularly tricky thing to pinpoint within that scheme. So on the one hand, you could say that law is superstructural because it's a way maybe of organizing how people live, but it's not also directly, involved in the process of the realization of surplus value in the way that, in the strong sense, when we think about technology, for example, technological development. But at the same time, it's also difficult to say that law is not part of the base, because law helps organize how human beings actually extract surplus value from the division of labor, right? What kind of subject you are, legally speaking, whether you have the right to sell your labor power for X amount of time versus whether you are bound to a feudal lord in a different country, are two very different kinds of relationships. And law obviously factors in here in terms of actually organizing that. So already base superstructure starts to fall away a little bit as a metaphor. How can we start to think of law as a social relation? So, or can we think of law as a social relation instead? How can we start to think of law perhaps as something that mediates between those two levels? Or maybe even we should move beyond that metaphor entirely. And part of the, maybe the conversation that we'll be having today, looking at, I think more arguably heterodox thinkers on law. So if Evgeny Khachaturian and Igor, among other thinkers, can perhaps help us problematize that initial economistic understanding where law is just simply functional to the production of the capitalist class.
Yeah, and then if I could just add, I think the emphasis on metaphor is very important because oftentimes it's more than a metaphor in terms of how it's treated. It's almost like an iron law history, if you will. And of course, even the most orthodox, at least at an earlier point in time, take Jerry Cohen, the analytical Marxist, right? His argument, functionalist argument, right, makes a big deal about the base superstructure metaphor. But ultimately, he says bases need superstructures because they need them. So you can imagine the kind of how one builds a house, you need to have a solid foundation. But if you don't have a roof, right, the house isn't going to last for very long. And the reason I'm mentioning this is because even if we take quote unquote orthodox Marxism, right, we have to also remember the Engels' correspondence, where he reminds readers, he takes some fault saying, perhaps Marx and I, because we haven't focused on the formal side of things, this has been an occasion for misinterpreting our materialist conception of history. But what Engels does in various letters to Schmidt and to Locke is to emphasize the extent to which the base reacts on the superstructure and vice versa. So it's not a unidirectional kind of relationship. So one metaphor, not exhaustive kind of explanation of the materialist conception of history, and two, you have them kind of working against each other and together at the same time, and that's also something that's very interesting. The other thing I wanted to mention, perhaps briefly, just to kind of highlight what Rafael brought to our attention, are these two thinkers that we're going to try to focus on. I don't like this discourse of heterodox, orthodox. It has a theological kind of, not that there's anything wrong with that, but sometimes instead of kind of thinking through the logical implications of arguments, we end up thinking about who's more pure and who's less pure. I don't think that's particularly constructive, but nonetheless, that's the history of Marxism too. It's part of that history. But when we think about people like Evgeny Khachaturian and Nikos Poulantzas, what's interesting about them is the extent to which they are open to the complexity of law and to legal phenomena, that it cannot simply be explained by the content of class domination. And I think that's something that's going to bring these two thinkers together. The extent to which they are orthodox or heterodox is much hotly debated, of course. And of course, there are also disagreements between them. It is the case that Poulantzas reacted, we think about the base superstructure metaphor. It is the case that Poulantzas, at least in some obscure writing, did respond very critically, in fact, in a hostile manner to Khachaturian. But they do have this much in common, that they want to find what Khachaturian calls the differentia specifica of law. What is it that makes law distinct from other social phenomena, right? What makes law different from politics? What makes law different from economics? Since law and political economy is a big thing here, right? So, and I think they have the tools to help us think through some of those questions to inquire. Maybe not always the solutions, but at least the
and just to add to that, what makes law distinct from economics, but at the same time actually can still legibly explain the connection between law and class power. Right, so again, moving beyond understanding of how the ruling class actually makes laws in its own interests, right? So the conventional understanding would be that, you know, the elite members of the ruling class, the kind of leaders of the most class conscious representatives of that class, are able to kind of calculate what their long-term political interests are, and their long-term economic interests, and to you know, have the foresight to then put those, use the institutions that are available to them in order to then generate laws that will be conducive to, you know, reproducing their class power. The problem is that capitalism is a fairly chaotic social system. The ruling class as such is actually more of a conglomeration of fractions of the ruling class. And it's not at all clear that their interests are all going to align. Especially economically, because we know that there are always competition with one another within particular sectors, but also politically perhaps, right? And some of the moments of state crisis that we notice are actually moments when different fractions of the capitalist class might have different understandings of what it is that makes sense to them politically for their long-term class interest. I say this in order to, again, kind of emphasize that law cannot just simply be taken as a reflection of the economic base. And part of what we're thinking about and where I think the conversation could be more productive is to understand how it is that we can connect the idea of law as it operates in a capitalist society to the reproduction of capitalist class power without at the same time falling into a kind of simplistic reflective model where either the ruling class just kind of directly compels legislators to, you know, legislate in their favor, or a kind of functionalist account, which is really the other side of the same coin of the instrumentalism. That basically says, well, that starts with how laws work today, and then kind of works backwards to explain then why, how they justify the existing state of affairs. So both of those, although they're in some ways different, or that they take different starting points, they both end up with a kind of what we call an economistic understanding of law.
Yeah, and just perhaps to add something that may connect here, Evgeny Pashukanis and Ellen Mexion's work, right? This emphasis on the separation of the political and economic under capitalism. So in many respects, Pashukanis anticipated this in his famous work, The General Theory of Law and Marxism. And he asked a seemingly kind of intuitive and innocent question, and that is, why doesn't the ruling class rule? Right? Why is it that law takes on this impersonal character under capitalism, whereas it didn't, right, in pre-capitalist modes of production and forms of production? Why is it that the ruling class doesn't rule directly? And why does law assume this kind of impersonal, quote unquote, seemingly impartial character? Now, Pashukanis' starting point wasn't a cynical one. For him, this isn't some kind of illusion, or some may refer to this as quote unquote false consciousness, but he actually thinks that what he calls the legal form, that impersonal form that law takes under capitalism, is actually an objective relation. That is the product of living in a capitalist mode of production, right? And in particular, right, where people exchange commodities, and some in particular to make profit, right? And so it really turns into the question of the form of law, right, rather than the content, because the knee-jerk reaction of the class instrumentalist approach is to say, well, all we can say about law is that it reveals class domination, right? You have a ruling class that dominates a subordinate class, and that's all there is to say about law. But the trouble with that point of view, according to Pashukanis, is it doesn't explain the characteristic form of the law, and why law doesn't take on a personalistic form, the form of direct class rule and domination. And so greater attention to the form of law, what makes it different from other forms of phenomena, politics, the military, for example, right, which is predicated upon hierarchy. Really kind of, for Pashukanis, it's really important to figure out what makes law different, right? Because the danger is the danger is that we're going to reduce the law to the state or to politics, right? But the failure there is to not be able to distinguish law as kind of a unique form of social phenomena. And his emphasis on the form of law rather than its content, he agrees that it conceals class domination in the final analysis. But that doesn't say anything particularly interesting about what makes law different, even for a Marxist like Igor and Shoikhedbrod. So why is it that the ruling class doesn't actually rule under capitalism? And that has something to do with the separation of the economic and the political. That's why I brought Wood in here.
Despite you joined us since started, so just want to let me mention also we'll be sort of having this conversation till about 7:10, and then we open the for questions from the audience. I wanted to actually ask you about the critique of sort of liberal legalism, so this the hegemonic sort of way of thinking about law. But I think since you're sort of already kind of there, maybe you can sort of follow up more on the sort of specificities of law, which is what is specific about law as a form of bourgeois rule, right? Which is something I think we already sort of started talking about. So maybe you can sort of continue on that and come back to the critique later.
So when we think about the specificities of law, or what we call kind of legal fetishism under contemporary liberal democracy, we have to ask ourselves, well, what are the basic premises on which the liberal understanding of the state, constitutional state, actually rests? What do we mean, for example, when we speak of the rule of law as a kind of general phenomenon? So one thing that it implies is, as Marx's kind of Marx famously critiqued in essays like On the Jewish Question and in other pieces, is a kind of basic separation between separation of human beings and human consciousness into two artificial domains, and that is civil society and the state. And the basic contradiction between those two is that civil society under capitalism, as it kind of coalesces as a web of social relations out of late feudalism, involves competition. It involves a kind of general set of social relations and a corresponding ideology by which people come to increasingly see themselves as kind of antagonistic, atomized competitors within a marketplace, right? And of course, Khachaturian and other figures say that actually this mirrors the kind of gradual spreading of market relations or market understanding of both the self and the commodity form as kind of the basic nucleus of this way of thinking. So on the one hand, you have civil society, which is the realm of kind of earthly competition. And on the other hand, you have the state. And the modern state emerges in its kind of initial form as absolutist state, and then the liberal democratic constitutional state in the 18th and 19th centuries as a new universality. That is, as a way of actually falsely representing to human beings their membership in a certain political community. So you have the kind of split between, on one hand, man and citizen. Right? So the citizen participates in the universality of the political community, whereas man is, or the bourgeois is the kind of epitome of this conception of citizenship. And then you have at the same time a kind of bourgeois conception of competition operating in civil society. So this separation between the political and the economic, or what we call state and civil society, is actually kind of one of the fundamental points of Marx's critique of the capitalist mode of production. Part of what it does, and of course this is itself a kind of you could say derivation out of how human beings actually have to engage with market relationships, right? So human beings increasingly encounter themselves not as members of let's say a guild or some kind of other kind of fraternal community as they might have in the medieval period, but as people who are compelled to sell their labor power for an X amount of time in order to sustain themselves, right? So you have that kind of process of atomization going. And at the same time, what happens is a process of increasing abstraction, right, in terms of citizenship and how you see yourself as participating in the political community. There's a kind of falseness of representation in terms of how you see yourself. And where law fits in is that law becomes a kind of ideological form to help reproduce and make that relationship seem all the more real to the person. We can talk a little bit more about legal fetishism, contractarianism, and the legal subject as well.
Yeah, well, I'll just mention, also bringing what Rafael said in connection to the question, right? If, for example, the class instrumentalists and reductions, all they see, and again, we're kind of trivializing to a great extent in order to bring out the distinctions here, okay? Is that if they only see in law class domination or direct class rule, then a liberal understanding of the law fetishizes the law such that the law is conceived as existing kind of above and separate from class. That law is a neutral kind of arbiter. You think of Lady Justice blindfolded, really balancing the scales of justice, right? Because all you're paying attention to is the form of the law, and all that law sees is everyone is equal. And it brings to mind Anatoly France's, Lisa Rouge, the Red Lily, where the law in its majestic equality, right, prohibits the rich and the poor from sleeping on the bridges, etc., etc. And so it's blind to the fact, right, of difference, you can say, of substantive inequality. And so the liberal understanding of the rule of law is predicated on a conception of formal equality that is blind to substantive inequality, the fact of inequality, right? But that is its starting point. It has to begin there because the basic presupposition is that we're all juridical equals, right? The law doesn't see the fact of class domination, the fact of class inequality or class relevant inequalities, and that's crucial to the liberal understanding of the legal form and the rule of law, right? That's sort of the starting point. And so, in a way, right, it's the direct opposite of the class instrumentalist view, because it's almost as though class doesn't exist in a liberal democratic society, because we're all free and equal and deserving of rights. The only difference, Marx says this, we're kind of homogenous in that way. Any differences are irrelevant, right, as far as entering contact is concerned. Right, the basic presupposition is we're not forced into contracts, right? We voluntarily enter into relations of exchange. Of course, Marx also says in Capitalism that we're free in two senses. We're free to go from one employer to another, and we're also free in that sense from the having any control of the means of production, right? Because he has kind of a deeper conception, not only of freedom, but you could say of effective freedom. So my point is basically that the liberal understanding of law sees it as kind of rising above class inequalities, so much so that class inequalities are irrelevant in a liberal democratic society. But we know, at least most of us here, right, if not all of us, that class does matter, right? But it's kind of the missing piece, the Achilles heel of the liberal legal form, which allows it, right, to kind of move on with its work by pretending that we're all equals. There is a certain truth to that, in the sense that we're all equal in a formal sense, rather than in a substantive sense.
Khachaturian also makes this argument that the modern form of law exists in a way to reify the understanding of the juridical person, the juridical subject. That is, somebody who is not bound by kind of obligations or in the sort of socially conventional understanding of the term, but it's actually kind of an atomistic or atomized subject capable of entering into contracts. And really, for Khachaturian's bourgeois private law or civil law is kind of the foundation of all modern day contemporary legal systems. But what I'd like to kind of add to what Igor just said as well is how this process of atomization and misrepresentation of oneself actually kind of cultivates a certain understanding of yourself as a juridical subject, right? As somebody who how so much of our understanding of who we are as rights-bearing subjects are actually forms of, let's say, interpolation, socialization into into ways of thinking that take place through various ideological institutions. So schooling, work, even kind of our free activities. And following Althusser, following Poulantzas, following that kind of strand of thinking about ideology and the relationship between law and state. One thing we can kind of point out is how part of, I know we're talking about law, but we have to also talk about the state and the way that the state actually undergirds law and legal systems and actually helps cultivate that form of juridical subjectivation. So, according to Poulantzas, what is the role of the capitalist state? Well, it has two kind of main purposes, right, with regards to class power and classes. On the one hand, it kind of organizes the fractions of the dominant class, that is the capitalist class, and helps them to reconcile their long-term political interests. So what capitalists are not themselves able to establish as their interest as a class, because they are, the division of labor in society and the division of capital and resources makes them competitive. The state actually has to act as a terrain on which that form of consensus is formed. So legislative institutions, courts, become means of reconciling competing class fraction interests and adjudicating between them. And at the same time, what the capitalist state also does is it disorganizes the working class. And what does it mean to say that it disorganizes the working class? Part of the mechanisms by which it does that is exactly what we were talking about, by actually socializing individuals into thinking of themselves as juridical persons, as individuals, rather than as members of a particular class. Or even when they do speak about group rights or collective rights in some form, there is still a kind of liberal individualism undergirding the way that discourse operates in courts and in sort of like legal adjudication, things like that. So it has this kind of disorganizing role where we all then encounter each other in civil society as somewhat agonistic subjects, or at least potentially agonistic, even by virtue of having to transact with one another in a variety of ways, whether that means going to a corner store to like buy something, or whether it means having to sell your labor power to your boss, etc. But then it also recombines those atomized subjects into other collective forms that are actually conducive to the reproduction of class power. So what might those forms be? Popular sovereignty, right? Like the way that popular sovereignty actually operates in bourgeois liberal understandings, whether it's in the kind of like history of political thought from, arguably from Locke up to the present, is a sense of the people. But the people are not rarely ever articulated along class lines, right? The people become this kind of amorphous mass that helps to undergird the legitimacy of the modern constitutional state. Democracy rests on the people, but what does that actually mean when the people themselves are, infinitely fragmented by a variety of divisions, and most importantly, perhaps a class. And then nationhood, the nation, becomes another kind of subset of that, right? So you have these kind of collectivities, membership in the people, membership in a particular nation, that come to serve a particular ideological function of actually papering over the class distinctions that emerge, and those are reproduced by legal means.
And I'll just add to really quickly on the Khachaturian side, right? He follows the legal thinker Gumplowitz in maintaining that dispute or conflict is at the root of law. If you don't have a dispute or conflict, then there is no law. I mean, it's more complicated than that because he thinks that the dispute has to be between two rival property owners. So that's actually something that they have in common. But unless that dispute is activated, law is irrelevant. So what Khachaturian will do in his work in the general theory of law and Marxism is to counterpose what he calls legal regulation, which is predicated upon opposition of interest, disputes, as giving rise to the need for law, and the state comes into being after that dispute to come kind of in between, to adjudicate between those disputes. So instead of thinking of the state being first, right? And then the dispute and contract coming after. It's the other way around for Khachaturian. So dispute is kind of at the base of the legal form, legal regulation, whereas unity of social purpose, he argues, is at the heart of the base of what he calls technical regulation. And he provides, somewhat, in my view, troubling examples, and I'll be very quick here. The one example he provides of a legal regulation, which stems from dispute, right, is who is responsible. If, let's say, a train derails, you want to figure out who's responsible, right? And you want to hold them accountable and achieve some form of corrective justice, right? Redress. But he says this would be foreign, right, to the understanding of technical regulation, where suppose there is something like, a question of how can we get faster from point A to point B, and we have freight trains in mind. We don't ask who is responsible for slowing things down, or for that matter, if there's a derailment, right? Who is going to pay the price for that? Who's going to be sued? Because our goal, right, is something that all of us share in common, to get faster from point A to point B, because there's this unity of social purpose. The second example he provides, perhaps more troubling, is the relationship between doctor and patient. In a bourgeois liberal society, if the doctor does something wrong and undermines the patient's well-being, rights, dignity, etc., they'll get sued. Right? They also have a protected association, and there's also insurance. I'm not going to get into that for simplicity's sake, but there is a presupposition of an antagonistic relationship between the doctor and patient. But under different circumstances, they actually have similar interests. The doctor wants to help the patient heal. The patient wants, ideally, to heal, to get better. So there is no opposition in their interests, argues Khachaturian. And so if you use the baseline of technical regulation rather than legal regulation and assume that both of them have a common interest, healing, getting better, then it's only, right, when there's a dispute between them that the legal form emerges. If we assume that they have identical or more or less overlapping interests, right, then the goal of the doctor, right, is to help the patient's recovery. So there's no conflict between them. And Khachaturian acknowledges that even if it means that the doctor exercises a certain degree of coercion of the patient, right, there is no antagonistic interest, because in both cases, the patient wants to feel better, to get that healing, and the doctor wants to help with that process. It's a purely technical matter, not a juridical matter, because the juridical stuff has to do with conflict and opposition of interest. The technical part is, how do we get faster from point A to point B? In the case of the train example, how do we heal the patient? It's a question of medical science.
Unity of purpose.
Yeah, so that they have similar interests and there's no antagonistic interest. So at least this is how he tries to counterpose two different ways of understanding, right, how things can be regulated. You could assume the juridical form where we have antagonistic interests and we ask who's responsible. That's the question of the rights, right, and the litigation. And the other approach is assume that we actually have common interests, right? We're not at each other's throats, or what C.B. Macpherson called possessive individualism. Rather, we see ourselves as having shared interests, unity of social purpose, which is what he thinks or thought would inform relations between individuals in a communist society.
So actually, now that we're going towards that, so let me and have a sense of what's the kind of the role and the nature of law and in a bourgeois society. Let's ask the question, therefore, could law play any role at all to sort of dismantle the society, even make major changes to that? In other words, is law pure sort of preservative instrument, or could it have any kind of other sort of function or role or ways of thinking about change, right? To put it in a Marxist sense, is there a role of law in the transition mode?
This is a very broad and contentious question, I think, within Marxist thought, going back to the late 19th century. I think you would find that a large majority of Marxist thinkers who are kind of, in canon would find themselves to be somewhat agnostic on this question, or at least that there would be, I think, room for an understanding of law where law can be selectively used in order to help develop class consciousness and actually raise the level of class consciousness. So the question is, to what extent do those atomizing effects that I spoke about within the capitalist state You know, to what extent do they function just uniformly and perfectly? Or are there certain fissures, moments within legal understandings of, you know, universality and exclusion from personhood, or a kind of broadening of what it means to be a legal subject that could potentially be mobilizing, play some kind of mobilizing role within class struggle. I think it's difficult to kind of say one way or the other, unless we're talking about more concrete cases and particular historical times. But I think it probably would be fair to say that Marxists have never kind of discounted the importance of certain social struggles around certain legal forms. You can think back to, you know, Marx's discussion of the working day and chapter 10 of Capital, how on the one hand, what this did was, of course, it helped create conditions where capital accumulation could proceed more efficiently. On the other hand, it did also generate, well, for one, it also just kind of improved the concrete lives of the workers who were involved in these processes, but it also perhaps acted as a point of further organization, of further kind of class mobilization. So we can think of things like that, of struggles around the length of the working day, maybe struggles around the right to free speech, the right to assembly and association, the right to organize in the workplace, as components around which the struggle would be on the legal terrain, at least to some extent, or at least it might need to be articulated in a legal form in some way. But at the same time, you also can't necessarily think of them as maybe more than defensive struggles, or at least not ones in which not ones in which the kind of stuff of revolutionary politics is going to ultimately rest.
Now I have a few more biblical references from Marx. So and Engels actually. Engels wrote a really fascinating piece on the housing question, right? Marx also had very interesting things to say about the right to work and class struggles in France. And they both acknowledge that kind of under bourgeois liberal framings, it's a pie in the sky to talk about this as kind of transformative, to talk about these rights or the struggle with these rights in transformative ways. But behind kind of these slogans, right, hides kind of a bigger political project. So I think actually, both with respect to the length of the working day, that the fulcrum comes from politics, which exerts pressure on the law. Because the law, I think, in Marx, in Engels, you know, if you read the piece on lawyer socialism or juridical socialism, which is all about the religion of the bourgeoisie, which is the rule of law and human rights, right? It serves a kind of a conservative stabilizing function. You find that in Marx, you find that in Engels. At the same time, if it's undergirded by political mobilization, then it does have the capacity to be more than it is currently, right? At the same time, Marx famously or infamously says in Capital that revolutions are not made by laws, they're made by politics, and we fight it out ideologically. But how do you achieve change? Well, actually, in certain contexts, at least Marx working in the context of the International Working Men's Association does refer to recourse to the law, which transforms, as he puts it, social reason into social force, right? And that's how people mobilize around certain political struggles and then press for legal demands, because that's also the language of the bourgeoisie. And it's not only the language of the bourgeoisie, it becomes the language of the workers too. But the danger is, of course, of fetishizing, slipping into this view that the law is somehow this neutral arbiter that doesn't see classes. And of course, what does that tell to working people? They know that their class position matters, right? Or what Max Weber called life chances. And of course it matters. So on the one hand, you have law as a stabilizing and conservative function. It's not revolutionary. That's what law is. And at the same time, if undergirded by a robust political movement, and it takes the form of legal demands, then it can change, right? And can potentially become transformative. But politics, right, is in the driver's seat. And that's what, at least in the case of balances, this balance of class forces is about, and the relative autonomy of the state and of law from direct class domination.
We are near the end of our time and we'll open up for questions soon. But the thing is, in our sort of event publicity, we promise people to answer the question that will there be law after the revolution, right? So we have to sort of get there and quickly. So will there be law under communism?
It's like the strawberry joke, and after the revolution, everybody will love to eat strawberries, even if they don't like to eat strawberries. Well, that's a complicated question. My interpretation has been, in my book, in a reconstructive attempt, is to think through the logical implications of Marx's materialist conception of history. So in the Grundrisse, he basically notes that every form of production gives rise to its own legal relations. And if we grant that capitalism is a form of production, and if we grant that future communist society is a form of production, then it will have to give rise to something akin to legal relations that is going to be appropriate to the needs of human beings living under the constraints or the possibilities unleashed by communist production. Those legal relations may be very different from the ones that we have come to know, these antagonistic, pressing rights against each other, the rights of possessive individuals. But it seems hard for me to, first of all, if we take Marx's critique of the Gotha program seriously, where he does talk about right, and bourgeois right in particular, basically describes a movement from capitalism to the first stage of communism as basically inheriting, right, intellectually, morally, economically, and juridically, right, aspects of the bourgeois society from which it emerges. So even if one argues that is left with the impression that there's not going to be a law, that you move to a lawless society, Marx's own portrayal of the first stage of communism is basically struggling with the standards of bourgeois right that we've been, inculcated with, and it's not going to be, a change or a transformation overnight. The other thing we have to think about is the extent to which, democratic planning and alternative ways of organizing production also leads to radical transformation, right? Not only in the social relations, but in terms of regulation, right? In our society, we have very little to no control over our workplaces. I would think that in a communist society, it would be the associated producers, as Marx says in Capital, rationally governing their interchange with nature and with each other in a manner worthy of their human nature. Right? Wouldn't that require some sense of what we owe each other? It doesn't have to be possessive individualism. Who knows? Maybe I'm just fetishizing the law again. I've been guilty of that, accused of that in the past. But the basic idea is we have to think through the logical, in my view, implication of Marxist theory, right? And at the same time, think about what life without law as such would entail. It would entail, I think, something that Khachaturian assumes, namely unity of social purpose in one mind. But even if we were to gather everyone in this room and ask, what should we produce and how should we produce it? I'm sure there's going to be disagreement about that, unless maybe some people disagree about that characterization. And if there's going to be disagreement, there'll have to be some system of figuring out how everyone can participate in the process of choosing between different alternatives, especially if we're going to be more free rather than less free. So that's my kind of cop-out, if you will. But I do think we have to think through the implications, right, of what it means if we're going to fight for a world without law. We have to think through the implications of that. And we have a duty, I don't want to be too much of a content, but we have a duty because there's a history. And here we are translating a volume on the revolution of law, which involved working towards a society, at least initially, without law, as we know.
I want to reiterate what Igor just said about the law in the transitional period. This question of, to what extent are sort of remnants of bourgeois law and what Marx calls the narrow horizon of bourgeois right actually persistent throughout, let's say, the transition, the period I want to call socialism before you actually reach a fully law-free and state-free society under communism. Interestingly enough, Lenin in State and Revolution would also write that what was happening after or what would happen after the revolution would be the retainment of the bourgeois state, but without the bourgeoisie, right? So once the kind of once the revolution had leveled class differences, you would still retain the state apparatus in order to have some kind of mechanism by which to transform society, but would no longer operate along the same lines or even with the same institutions, because immediately as soon as one captures the state, one also then has to implement measures by which to abolish certain of its functions and transform it as well. So there's that point, but the reason why I come to Lenin is because one of the things that I think is quite important for him, as well as for Engels and for Boulanzas and many other Marxist thinkers who are concerned with this question, is the division between intellectual and manual labor, and what that would mean for a revolutionary society. Because if if anything is based on a form of intellectual labor, a certain form of intellectual production, it's law, right? Law, one of the ways that law has a certain relative autonomy, that it's not just a kind of linear reflection of economic interests, is because over the course of centuries, law in the kind of modern capitalist form has also generated institutions and certain practices that actually help reproduce both itself and the state as somewhat self-imposed domains of activity, right? So you have the emergence of legal statutes, legal codes, courts, lawyers who are then part of a kind of cadre, who are not a class, but certainly are a group of people who specialize in a very technical and particular kind of language that is broadly inaccessible to the vast majority of people. Right? This is one of the ways that Boulanza says the state reproduces its reality by virtue of actually promoting this understanding of law that is that nominally speaking is actually kind of open and accessible to all law. Liberal democracy is great because all laws are public, nothing's kind of kept secret. But the contradiction or the opposite of that is actually, who can legibly interpret all of this increasingly complicated arcane set of rules and regulations are actually a very small group of people, right? So that's kind of one of the fundamental questions that we would have to encounter in this transitional period. Is how to actually perhaps simplify law, and here maybe we might be getting towards much economists, or a kind of certain understanding of making law less complex, opening it up to an actual truly democratic understanding of how it is that we wish to, organize ourselves as a society and help plan production, help plan a kind of common way of life. And I think I'll just kind of leave it with that, because I think that this is an open question, but one that is absolutely crucial, that breaking down of the difference between intellectual and manual, so you no longer have specialization of knowledge in that particular sense.
And I guess, just to add that it's a double-edged sword, right? We also have to think about the problem of scale. If you're dealing with a very large population, heterogeneous interests, it's a lot more difficult to come to a kind of an overlapping consensus or some kind of consensus to begin with, right? It's a lot easier to do that in a small scale community than it is in kind of the context of a modern state and complex forms of production and organization. And trying to simplify things may seem to be more democratic, but it may also restrict those, the scope of people's rights, right? So maybe that's why people don't represent themselves in a court of law and have these lawyers. So I think it's a struggle in many respects to both democratize the law, right, and make it do what it wouldn't otherwise do, which is not easy to do. I think to democratize the law, because it has this conservative and stabilizing function, and so you want to emancipate yourself from law, but at the same time you end up making it more complicated as a result.
Thank you. Pleasure. I'm sure there are many questions. What we can do is actually go around, because the Zoom, we need to have your questions in the mic. And so just raise your hands and come to the mic. Sorry, Chase.
Hi, thank you so much. What practical impact do these critical visions of law have in the Soviet remaking of the Russian legal system or legal reforms in other countries that are communist-led or have strong communist parties, whether PRC, Vietnam, Emilia-Romagna, Kerala? And just curious, what's the practical upshot of these critical visions of law in legal systems?
So to start with, we're quite selective because we go from 1917 and the immediate aftermath of the Bolshevik Revolution, the October Revolution, and it concluded in 1931. So it goes through phases. The earliest phase is an attempt to radically democratize the law by getting rid of the old codes and passing a whole series of decrees on the courts and so on, trying to make laws far more transparent, public, and accessible, and trying to involve initially, an undereducated and illiterate population in the process of judgment, right? There are also the comrade courts, right? An attempt to really democratize. But then what ends up happening is, for various reasons, internal and external, because of course, Soviet development wasn't particularly conducive, to, we can go into that, to the kinds of things that we were hoping to achieve, right? Making law simpler, right? And then going through rapid industrialization through the use of terror and forced collectivization. So the point is that initially, anyway, they were very imaginative in their attempt to try to distance themselves as much as possible from the remnants of the bourgeois legal forms. And that meant making law far more accessible, getting rid of experts. In fact, they were trying to get rid of lawyers, and getting rid of law schools. I mean, that must sound like anathema for many people in this room.
Sounds great.
Sounds great. But so that worked for a while until it didn't, right? And so what they tried to do initially was to pair kind of experts, legally trained experts, with kind of lay persons, if I can put it that way. But then the circumstances, geopolitical and internal, weren't conducive to this kind of democracy, the revolution of law. And so what ended up happening is there was a return to the bureaucratization of justice. So you need a professional kind of exactly what Rafael, kind of mirroring Weber, was talking about. A professionally trained legal workforce that would be able to dabble in this complicated language. So on the one hand, there's initially this movement to democratize the law through the revolution of law, and then the conservative force of law kicks in with the work of people like Andrei Vyshinsky, right? Whose goal was to, make Soviet justice great again, in the sense that, I know a terrible thing to say, but really to give law that aura of legitimacy that it lacked, right, in the early years of the Soviet Union, among the legal theorists, because what they wanted to do, right, is to kind of separate themselves from the legacy of bourgeois private law initially, and all forms of law thereafter. That's the early phase, and then, quote unquote, Stalinist reality, I'm trivializing, kicks in. But Vyshinsky is the right man for the job, because what he does is he wants to legitimize law through the means of terror to justify whatever the policies, right? So their politics outpaces any kind of legal, and law really does become an instrument, except of a kind of state-led domination, right? So that Stalin, and not only Stalin, an entire society, has a justification for the, the purges and the terror, right, using the law, right? So it's legal, and what Vyshinsky is most famous for is the confession innovation, right? So you torture someone and they confess to a crime they didn't commit, but you got their confession, and that speaks to legal reason. As diabolical as that may seem, he took credit because it emphasized not an irrational aspect. Here is the allegedly guilty party admitting that they're guilty. So more like bourgeois law, responsibility, rights, except in the service of terror. Oh, yeah,
one of the figures that we've encountered in our research for this volume is a man by the name of Alexander Borchardt, who was an early influential Soviet jurist and legal theoretician. And he played a leading role in drafting and passing the new Soviet Civil Code of 1918, and well, pardon me, 1922. But one of the dimensions of that code was actually the way that they consciously tried to transform gender relations in Russian society at the time. So it legalized the right to abortion. It gave women the right to vote. It also legalized divorce and streamlined the divorce process very easily. Because part of the reasoning was that women's subjection to kind of patriarchal social norms went hand in hand with the development of bourgeois capitalist understanding of the family and of social hierarchy. So actually by opening up that process, by making all of these channels actually much easier for women, and actually being able to bring women as legal subjects into the process of Soviet construction, of socialist construction. I mean, I think that that's an interesting example of a kind of contradictory understanding of legal subjectivity for what I was talking about a moment earlier, right? So on the one hand, yes, there is interpolation, there's socialization perhaps into a new form of, into a new legal identity, to a new form of legal person for women who have been emancipated from Tsarist social norms on the one hand. But on the other hand, there is a dimension of freedom. There is a huge dimension of equality that I think can't just simply be brushed off as subjection basically to just a new legal form of it, and therefore this is something that we have to just kind of push aside. But again, that kind of speaks to I think the contested and contradictory nature of the way that law would function in a transitional society.
And for the record, Khachaturian was institutionalized, this drafter of the first civil code with radical transformation in property relations. So that was his fate. And then rehabilitated, but after being institutionalized. And this was one of the lucky kind of beneficiaries of the Stalinist era. Others were simply shot. And Khachaturian being a case in point. But he was not alone. There were quite a few of them. Really imaginative, really radical. But all of them, nearly all of them were killed in 37, 38. So that too, we have to think through the logical implications of working towards the end of law, which all of them were committed to, even Khachaturian.
Okay, thank you so much. It's very loud. Thank you. I really learned a lot. I have a question about the last part, which of course raises a lot of questions. So yes, every form of production gives rise to its own legal relations, but the difference with communism, of course, is that it's the first class of society. And you could say that that would be the end of conflict. I don't know if I think that is actually possible, but you could say that. And there would, of course, be these disagreements about what to produce and how we should produce it. But could these not be resolved with something like the technical regulations that you spoke about earlier? Is law absolutely necessary in communism? Could it not look so different that would not really be law at all? I'm interested because of the relationship you brought up between dispute and conflict and how that gives rise to law. Thank you.
So I guess I will continue with my biblical, as I call them, the biblical references and passages. So I quite like, although I'm critical of what Engels has to say about the government of persons being replaced by the administration of things. So I think that was actually the inspiration for Khachaturian's distinction between technical and legal regulation. In one case, you have dispute, the government of persons. You have some, governing over others versus the administration of things, where it's just a technical matter, right? How can we be more efficient? How can we be more productive? How can we get faster from point A to point B? How can we heal sick persons? Right? There's no conflict of interest there. But the younger Engels, right, in his speeches at Elberfeld, talked about the extent to which legal and judicial bodies could be eliminated, many of these institutions, because there won't be so many conflicts in this future communist society where people's manifold needs, and he even says spiritual needs, will be satisfied. But he still allows for the possibility that there will be conflicts, and he says, if you could read it for yourself, speeches at Elberfeld, they will be easily resolved by arbitrators. So who are arbitrators? These are third-party, individuals who have some sense of justice, I would hope or think, who step in the middle and try to balance, right, whatever disagreements will exist. So I think Engels, we need to give him credit. He at least allows for the possibility that there may be disagreements. This is what I said. If we were to ask everyone in this room, sure, we're living in a class society. I'm not going to dispute that. You're absolutely right. But chances are we will have different interpretations. But we have to figure out a way of working together to achieve something close to unity of social purpose. But that's easier said than done. It's an empirical question. It's not, something that just could be willed into action. The danger, I think, of kind of superimposing this vision onto the future, right, is that we don't think through the possibility that there will be these fundamental disagreements. And then the question is, how do we solve them? I agree with you, it doesn't always have to take on a legal character. It could take an ethical character. But what if I don't share, your sense of morality? Then what? Right? So I think, we have to think through these questions carefully. But my worry, and maybe this is my, juridical fetishism again kicking in, right? Suppose I am the patient and you're the doctor, and you tell me that I know, the best way of healing your ailment, and I'm trivializing here, it means amputating your leg. And you know better because you're the doctor, right? I'm the patient, and apparently you don't have antagonistic interests. But what if we do? And not stemming from class, but from other sources of disagreement, right? That's the danger, I think, is that all we see, in disagreements are of a class character. Even Marx, in that famous preface to the contribution of the critique of the political economy, says that yes, the social contradictions are going to be resolved, but not individual antagonisms aside. We will still disagree, but we will have more reason to agree with each other. It doesn't mean all disagreement will cease to exist. So with that limited disagreement, how should we resolve those disputes? And if it's not going to take the form of law, what form should it take? Technical regulation talks about means and ends. It doesn't tell us what's right and what's wrong. And I have a worry about that, because who's going to tell us what's the most efficient ways of running, freight trains, right? What about human dignity and all the rest of it? Not all of that is a bunch of bullshit, right? That matters too, I think. But maybe I'm just fetishizing.
I think I fall within the instrumental sort of reductionist camp of explaining the law, because at the end of the day, I don't see that legal structures do anything but uphold and buttress or facilitate the owning class dominance. Even in instances of where there's a fight by workers for better conditions, if they do get unionized and recognized, that doesn't really change their status as wage laborers. It sort of greases the wheels. One thing, I don't know if you could comment on something that I see, I think that we all see happening is in more and more societies, there's a warlordism or the cartels. In Latin America, in parts of other continents like Africa, you see the total suspension of the law. Where you have like countervailing forces, where the states, the governments are basically irrelevant. If you want something and you're a warlord, you just go and take it, and it doesn't matter how many people you mow down, because your the entities under your control are actually stronger than the state in that given region. I think this is a growing phenomena more and more as the system declines.
I agree with your points on the question of unionization and labor organizing. I think it's clearly accurate to say that these are still people who are, we still haven't exited the wage relation. I think the question, and this is maybe more of a situational or kind of conjunctural question, is what does this kind of mean for working class organizational capacity for the future, right? If we think of if we think of class struggle as a process, what is this, what kinds of possibilities politically and mobilization does this open up in the future? So there's a kind of, when we talk about something like, you know, perhaps using legal or illegal means in order to organize labor. On the one hand, there's a kind of defensive stance, which is that we just need to do this because this is going to concretely improve the conditions of people's lives in the here and now. And then there's a kind of forward-looking sense of, you know, Lenin's distinction between trade union and then consciousness and revolutionary or political consciousness. What does this mean for organizing for the future? On the question of warlordism and kind of state capacity, I think that you're right to say that there's a danger of, when we talk about law and the state, of projecting a certain uniformity of what the Rechtsstaat was, and in this kind of idealized form, out of its European forms, the parts of the world that never actually had that kind of structure, or at least where that structure was imposed imperfectly through means of kind of colonial domination. I think what I always kind of think about, though, is the way that relationship has now also rebounded back on even the model of the constitutional state in Europe or around the global north. What you're pointing out is the kind of what people might call the crisis of liberal democracy, what we might call the kind of legitimation and social reproductive crisis of capitalism in advanced capitalist states, is that increasingly increasingly the state is incapable of actually fulfilling certain necessary functions, which are capital accumulation, which they're still doing very well, and I don't think that that's much of a problem, but social reproduction and ideological legitimation are both faltering, not just in the global south, but in the global north. The other point, and there is a strand of Marxist legal thinking and state thinking that actually upholds the rule of law as something that is a point of as a means of imminently critiquing those how states just don't actually live up to those aspirations, even in their most perfect form. That increasingly, with the rise of the modern administrative state, more and more aspects of state activity actually fall outside of legal oversight or regulation of any kind. And I think that there's perhaps something to that critique, and I certainly wouldn't kind of oppose counterposing how states fail to meet their own ideological projections. But again, I would come back to this idea that we can't actually just leave it at that. And that actually the critique of law in the state needs a more robust, I think, point of attack than just speaking about the rule of law.
And I would just kind of emphasize that perhaps a more constructive strategy is not to say law and non-law or not law, but rather something that comes to the fore in Marx's discussion, right? In this discussions with debates concerning the length of the working day and what is accomplished. His language is that of an antinomy of right against right. So it's not that you have right and no right. It's this kind of dialectic, if you will, right, or a counter movement, if you want to use Karl Polanyi's language, right, where it really is a question of who will prevail politically. Now, most people, when he says between equal rights, force decides and force prevails, they assume he's talking about brute force. He's talking about class struggle. He's talking about the class struggle, and the class struggle can lead to a certain understanding of right that benefits the workers, or more likely, the kind of right that will try to squeeze out as much as possible out of the workers, pay them as little as possible. But that's what the capitalists want to accomplish. The workers want to accomplish the very opposite of that, in keeping with their bodily integrity, to broaden the scope of the right. But they're still working within that language, because that's our language. That's the language of the bourgeoisie, and we still live in a capitalist mode of production. So I kind of like this discussion of the antinomy of right against right, rather than right on one side and no right on the other. And of course, E.P. Thompson, before he became a big rule of law guy in the last 10 to 11 pages of Whigs and Hunters, right? He wants to say that there's more to, right, kind of the facade, right? That sometimes even the ruling class has to adhere to its own lingo, And sometimes it does, more often than not, it does not. But that still gives a terrain of struggle that the workers shouldn't disarm themselves against, especially, the more and more they get oppressed, the more and more they get squeezed, and especially at a time when civil liberties are being attacked right and left. So in many respects, I think that we cannot give up the discourse of rights at a time when the ruling class has more and more of them in the form of privileges.
Yeah, I wonder if you'd like to say a little more about the criminal law and the state's bodies of armed men, mostly men still, courts, prisons, that whole, the repressive apparatus of the state as part of the legal apparatus, which beyond every other thing you guys have said tonight, seems to be missing some attention that ought to be due to it.
Well, yeah. Well, first, it goes back to kind of the conservative and stabilizing function of law. It's not meant to be revolutionary. So there is a sense in which it's, it still kind of organizes relations in such a way that it benefits the ruling class. And of course, that goes hand in hand with the military-industrial complex and all the privatization, even in capitalist societies, that have just intensified over the years up to the very present. So that's something that has to be fought against. But connecting to, I guess, our volume in translation, right? The early Soviet criminologists were all about rehabilitation. There's a danger there too. Why? Because what they wanted to do is to change the discourse of kind of the criminal who has to be punished, and change that into a question of how will they be reintegrated. But then they also changed, the lingo or the discourse of the criminal into the social danger, right? And society is a kind of a vulnerable subject. Now then, who gets to decide who constitutes a social danger? So even in this kind of revolutionary context, it can become dangerous because for ordinary individuals who happen to be deemed social dangers, right? They may become victims of injustice even in a regime claiming to act in their own interests, right? So this is something of a puzzle we've encountered in some of these early theories that we're translating, because on the one hand, you want to get rid of these bourgeois categories, which reinforce the class domination. The people of color, indigenous peoples overrepresented in the criminal justice system, absolutely. But they also have some rights, and those rights are being undermined every step of the way. So there is also a danger involved in shifting the discussion of an agent who's responsible for their actions, to kind of an agent who constitutes a social danger. And that there's a lot of latitude there for the state to exploit that. Not only for the bourgeois state, but a would-be socialist state as well. And so the formal rights of the accused, I think, also matter. But obviously that's not gonna, it's not gonna do away with a racist, right, repressive state apparatus with which we are working, globally, and especially in North America.
I just want to tag on to that. This maybe just a very simple and straightforward point, but when we talk about repressive and ideological state apparatuses, we have to think of these less as a dichotomous category and actually more as a Venn diagram, or at least one in which there's maybe a spectrum, right? So when we think of something like police power or carcerality, I mean, can we just simply kind of attribute this to the repressive state apparatus, but also thinking of like how the police in modern capitalist society actually play a ideologically legitimizing role, right? And in terms of what this, not a class, right, but I guess a status group of some kind or an occupation perhaps reproduces and stands for social order, right? It stands for the kind of as police say that we are the line between order and anarchy, right? The constant threat of possible social disintegration that's just right around the corner, unless you have this institution that actually holds significant political power, right? At least in the sense of the influence that it has upon cities, townships, locales, and so forth. So all of this is to say, I think that When we talk about questions of law and, states of legality, we also have to think of how that operates always under the backdrop of certain ideological understandings of what society is actually based around and how that society works. So in a way, part of what actually makes up autonomy, it's possible to speak of something like the autonomy of law, where law isn't just kind of directly, reflective of whatever the ruling class might want at a given moment, is that it might be more useful to think of as that ruling class is itself based upon certain shared ideological understandings of what is good for them, both politically and economically and socially. And law has a certain degree of relative autonomy within that space to kind of actually legislate and enforce what, a mediated understanding of what those interests actually are. But again, all of this is just to say that usually when we speak of state apparatuses, they're always entwined in this way.
Yeah, piggybacking off that, I was wondering about imperialism, because the things you mentioned in the beginning about the interests of like the individual capitalists versus the capitalist class at large clearly seems to apply. Clearly, it's in many ways the same apparatuses, right, in a bourgeois society. In most of them, it's the legislative body that declares wars. And also, if my memory doesn't fail me, I think in the discussion of the working day that you brought up, it is also true that he has a discussion about the British state actually having an interest in the bourgeoisie not working the workers so much into the ground that they can't play their soldier roles anymore, right? So in that sense, there's in that domain very clearly a sense in which the necessity for the state to be able to project this imperial force in itself generates interests that can be interfering in their own way in this immediate class struggle. So in that sense, it seems to me that thinking about imperialism is useful for thinking about laws. I'm wondering if you have thoughts about how thinking about those two domains can be fruitful, one for the other.
Yeah, and Marx's position, right, on emancipation, right, and how important, right, the struggle against chattel slavery in the United States was, right, and the push coming from the working class, right, of the different nations, countries. I think you're absolutely right. Now, in terms of what the implications that has for law, is that it's always going to be the seesaw of struggle, right, between different and competing class interests as well. And what that means is that, the kind of solidarity in a meaningful sense, not in kind of a symbolic sense, has to be global, because if it's not global, then it will give into these kind of games that are played and devised by ruling classes to divide the workers through this policy or strategy of divide and conquer. And unfortunately, in many instances, it works, right? And we know, and it's the World War I, World War II, and we can go on and on. All the other kind of murders that we don't pay as much attention to as well are kind of products of this divide and conquer approach that divides the working class. So it's true that the ruling class and the bourgeoisie they all don't get into a room together and and scheme. First of all, I don't think that's even possible, not even on Zoom. Believe it or not. But even if it were possible, right, they tend to have more homogeneous interest in screwing over the downtrodden, and it's a lot more difficult, right, to mobilize globally around the interests of all workers, sometimes competing with each other, because capitalism is not conducive to cooperation, right? It destroys that. But it also, at least according to quote unquote orthodox Marxism, right, produces this gravedigger that sees that they have mutual interests, regardless of which nation state they are part of. But that's a tall order. It's easier said than done. It's easier to look that the workers have no nations, right? That they have a world to win, and it's a lot more difficult to mobilize and cultivate that sense of solidarity that is so urgent today, right? Precisely to fight off against these imperialistic wars.
I'll just add that I think that that's a really wonderful example of what we talk about when we talk about the relative autonomy of the state and the state actually able to maybe see in a way, or at least work to see in a more long-term perspective than the interests of particular capitalist classes, right? Now, to what extent is that state autonomy, and then that relative autonomy, forged within the context of the modern European imperialism, I think we absolutely have to recognize that it was. And actually part of the way that, even in the 19th century, you already saw it having to intervene in order to mediate between different interests of the different factions of British bourgeoisie, right? So kind of like the financiers who were pro-imperialism because everything that Marx writes about in the Communist Manifesto, the bourgeoisie is tearing down old walls and kind of spreading around the globe, versus you could say maybe like domestic manufacturing interests, domestic agricultural interests to some extent. So again, the state is this kind of institution terrain that's a mediator, and law in a way is actually one of the means by which it's able to reconcile these antagonistic positions within an imperial context.
If there's no other question right now from the room, there's a question from Zoom from Abby Scribner. It says, could this panelist speak to Simon Clark's critique of Spinozas's theory of the state, and if this leads to a different understanding of the law?
Thank you. I guess I should fix this way. I think Clark's critique is probably the most compelling out of the critiques of Spinozas, at least I'm kind of familiar with. I think part of what we mentioned at the beginning of the talk in terms of how we understand the relationship between the political and the economic in modern capitalist formations is precisely where Clark draws differences between his approach and Spinozas's approach, in the sense that Spinoza takes a more refined understanding of what that separation between the political and the economic is. I think maybe without getting too much in the weeds here, that I think that it's possible nevertheless to reconcile certain elements of what I would consider to be a kind of Spinozasian relational analysis and a more value form or commodity form analysis. But I think it would require a lot more theoretical work that needs to be done. Part of which might be actually looking at how Spinozas changed his subtly changed certain positions of his between his earlier more adversarial work and some of the later pieces that he wrote in his final book, which Clark, to my recollection, does not engage with as much as the earlier, more quote unquote structuralist. Yeah.
Okay, thank you very much. Thank you very much for this fascinating talk, and thank all of you for attending. We try to have this once a month, but not in May when everyone's free time, or just go for the summer break. So maybe next semester. So if you have registered for this event, we'll send you maybe for the next session of this series. I hope to see you again there. Thank you very much. Thank you. I know. I should that because no one was standing at that.
Oh, of course. Because then you get like big exterior doesn't fly, I said at least building some stuff.
So you all talk about Andrei Shinsky.
Well, they didn't tell a lot because